Good evening, ladies and gentlemen. Welcome to a Safety Act Town Hall. I am joined with my colleagues, partners in crime in the Illinois legislature, the Freedom Caucus, the Illinois Freedom Caucus. We're here to talk about the Safety Act. I'm here with Representatives Chris Miller, Blaine Wilhauer, Dan Calkins, myself, and Brad Halbrook. But folks, we wanted to open this up. That's why we're having this evening. You're wondering, what is the Safety Act? How will it affect you? And what is it going to look like here in January? So we brought some experts in, folks, experts in their fields. We have Effingham County Sheriff Paul Coons. We have Macon County State's Attorney Scott Reeder, and we also have Adams County Judge Robert Adrian. So we're going to cover a myriad of topics here for you this evening. We're going to jump right into this particular issue on the Safety Act. I know there's a lot of questions, a lot of concerns when it comes to this particular piece of legislation. We see the governor backstepping. We see Cam Buckner, a sponsor of this legislation, backstepping. It reminds me when Nancy Pelosi said we have to pass the bill to know what's in the bill, and we're starting to see that this egregious piece of legislation. So we'll go ahead and get started. We'll start with some introductions. Chris, would you like to introduce yourself, please?
Sure. My name is Chris Miller, and I'm the chairman of the Illinois Freedom Caucus, and I represent the 110th District, which is Coles, Cumberland, Clark, Crawford, the city of Lawrenceville, and 2 townships in Edgar County, Kansas, the big city of Kansas, and Grandview. And welcome, and thank you for joining us tonight.
Thanks, Chris. We'll move on to Representative Blaine Wilhauer.
Hey, Adam. Thank you. It's good to be here tonight, and special thanks to the experts that are with us here tonight. This is a really, really important issue. Obviously, public safety should be the #1 issue in state government. Unfortunately, it is not what we've been seeing. This governor and this legislature is willing to cast aside the public good all too often for their political agenda. And what we have seen with this Safety Act is a major failure to protect the people in the state that are the most vulnerable. And there's a lot of misinformation out there, and a lot of it comes from the governor. The governor wants everybody to believe that, as he said yesterday in his press conference, that all the Safety Act does is, it keeps single mothers who are shoplifting diapers out of jail. That is absolutely not the truth. That's misinformation. What this act is doing is setting it up give our law enforcement officials and serious problems on keeping dangerous people off the streets. So we think it's extremely important to get this information out there, and the only way we're going to change these things is we hold politicians accountable and change politicians where necessary. So I'm looking forward to diving into this, and I think that everybody's going to find it informative. So thank you.
Thank you, Representative Wilhauer. We'll go to Representative Dan Calkins of the 101st District. Dan?
Very much, Adam, and everybody. It's great to hear a very lively discussion. Bills that get passed in Springfield, duties and supposition. We're going to have to lead judges and states attorneys, and most importantly, I think it's going to be up to us voters. We have to decide: are we going to send people back to Springfield? This bill that have seen threats about it, but I look forward to hearing tonight. This is, I think, a big, including me.
Thank you, Dan. And we will go to our expert panel. It's a good thing to hear from other folks rather than the representatives that have fought back against this bill on the House floor. So we have Effingham County Sheriff Paul Coons. Paul?
Yeah, thank you, Adam. I've heard it twice now referred to as an expert, and that worries me a little because I have a lot of questions about this bill. It dramatically changes the way that the police officers will do business. And there are some questions that still need to be answered, and we're researching it. There have been some changes in the bill that have helped, but there is still a lot of information needs to get out there. needs to get to the people that are going to have to implement it. And there are some things yet that I believe still need worked on. So, here we are, and I'm really hoping that I learned some things tonight.
Thank you, Sheriff. Thank you. And we also have Macon County State's Attorney Scott Reeder with us this evening.
Good evening. Thank you for having me on. I'd be happy to answer any questions. I am a state's attorney in Macon County. I've been involved in criminal law enforcement and defense, both for the last 39 years. The new act is quite a bit of legislative pudding. It's put together rather poorly, quite frankly, in my opinion. But we can discuss that as we get into the events. I do notice a citizen comment already saying that we should read the act aloud to start so they know exactly what's in it. Again, that's referring to the Nancy Pelosi in a way. We need to pass this bill so we know what's in it. But the problem is the act is extensive. In fact, just the limited changes that we intend to talk about tonight, the Bail Reform Act, is an extensive rewording of the act as well. To read it aloud would probably take most of the hour and a half we have allotted. So hopefully we can answer some questions, though. That's all I have if you're waiting for me to.
I see Adam is maybe down for a second. I'm sure he'll get that back up and running.
It looks like Adams is frozen. The only one who hasn't introduced themselves is me. I am Circuit Judge Robert Adrian. I am a 12-year circuit judge for the 8th Judicial Circuit. I am seated mainly in Adams County, although I do cases in other counties also. And I have extensive experience in criminal law and doing felony cases.
Thank you, Judge. And I had not had a chance to say anything, so I appreciate the opportunity, guys. Brad Halbrook, State Representative.
Thank you very much for joining
Adam,
us.
are you there?
And lastly, we have Adams County Judge Robert Adrian. Judge.
Okay. Again, I am a circuit judge from the 8th Judicial Circuit. I've been serving for 12 years. I am seated mainly in Adams County, but I do go to other counties for cases. I have some extensive history and experience in criminal cases, mainly felony cases.
Judge, are you there?
Yes. You continue to get frozen.
Well,
on
it looks
my
like we're having
screen.
some technical difficulties, so we'll just jump right in to this particular issue. So the Safety Act was passed during lame duck session and the 101st General Assembly at about 4 in the morning. I know the comment was, read the bill. Well, we didn't have a chance to even read the bill. It came through at 4 in the morning.
Yeah, it looks like Adam is frozen up here. Representative Halbrook didn't get a chance to introduce himself here and give his thoughts. Brad?
Thank you for that, Blaine. And so Representative Brad Halbrook, Shelbyville, the 102nd. It's all of Shelby, Moultrie, Douglas, Southern Champaign, most of Edgar with a little Vermilion and a little Macon. Guys, we've got a great program lined up for you this evening. I'm looking forward to the discussion between the 5 of us and the experts that we've invited on and have accepted the invitation to be here. And so we thank you all for joining us. And so I'm hoping that we're going to have a very lively and robust discussion. Please, I know we've seen some folks already leaving comments. Leave your comments and questions. We'll try to get to those throughout the evening or as the evening wraps up. And if not, we'll hopefully maybe be able to try to answer those later. A lot of questions this bill. Like it was mentioned earlier, this was passed in the wee hours of the morning on January the 13th, 2021, in the dark of night when no one else was able to be looking at stuff. And so this is a big bill, 800 page long bill that had multiple enactment dates. And we're coming up on January 1st of an enactment date. And I think some of those things is what we're going to discuss here tonight. So with that, Blaine, I'm not sure how Adam's doing on his connection, but I'm going to throw it back to you, Blaine.
All right, thanks, Brad, and thanks, guys, for that introduction. As Adam was trying to say there when he was having some difficulties, just the manner in which this was passed through the legislature.
Can you hear me?
There were real issues with it. This was dropped on us at the dead of night. Nobody had a chance to read it, which is pretty typical of some of the legislation, especially the major legislation that happens. As we're seeing right now, there's a lot of confusion. I don't think the governor even knows for sure what's going on here. But the biggest thing that is sticking out to people right now and is in the news is the non-detainable offenses that have been out there. I think everybody's seen the graphics on this, and I just want to ask some of our experts what their thoughts on it. What we're seeing for non-detainable offenses are things like aggravated battery, aggravated fleeing, arson, burglary, drug-induced homicide, intimidation, second-degree murder, and threatening a public official. These things are put out there as non-detainable offenses, meaning that if you commit certain amounts of these crimes in certain situations, you wouldn't have a chance to be subject to the bail situation. So we'll start with the Macon. I would like to hear your perspective on these non-detainable offenses and were this stuff legislation.
Well, and let me just start out by saying a couple of, I see I have a cat in the background. Let me start out by saying a couple of things about the law itself and the passage. First of all, I don't want to refer to this as the Safety Act in my personal opinion, because most of what it does not make our community safer. And again, this is my opinion, but it doesn't. What the law was intended to do in this part, when we're talking about tonight, the bail reduction, the idea is that there are certain groups in our society, communities in our society, that are economically disadvantaged, and so that they are set at a different ability to achieve pretrial detention than other members in our community. I understand that argument. I understand that's the problem. The first thing, though, I'd say in response to that is that the law that exists already can accommodate for that philosophy. Judges have the power, if they believe that someone is being unjustly detained in pretrial detention for whatever reason, whether it be basis of the charge, whether it be based on economic reasons, judges can already determine that they're going to release somebody without cash bail. They can simply give them what's called a recognizance bond. So we didn't need to throw this big monkey wrench, this political activity, quite frankly, into the system to adopt or to change what people see as an injustice. What we could do is to talk to judges, to reason with the judicial bench about the things to be observed in the laws exists already, to be taken into consideration, rather than developing this whole system, which is not well thought out and which is not well planned out in its execution or in its majority. So that's just sort of a general overall comment I wanted to get out there. To answer your question directly, Blaine, with respect to the charges, there are a specific list of charges to which someone can be detained. And you see an infographic out there now, it's been making its way around the internet, about the list of offenses that can't be detained: burglary, arson, kidnapping, robbery. Because those are all offenses that under current Illinois law, for a first-time conviction, you can get probation. So one of the main things that's in the law, and there's a number of sections that have been written into it, one of the main things in the law is that you could only be detained for offenses for which, if you are convicted, you have to go to prison. And things like a first-time arson or first-time burglary are probationable, so therefore do not qualify as detainable offenses. As people may expect, we were online among ourselves before, and with the sheriff, he and I were talking, and the issue came up is that, at least from a state's attorney's perspective, if you commit a second burglary within 10 years under Illinois law, it's non-probationable. So we believe we have an argument that on burglaries, if it's a second offense or if there's other qualifying offenses, we can still argue that they could be detained. Whether or not that will be held to be legal under the current law as it exists now is something that the courts will ultimately decide, but we believe we have a good argument for that. But aside from non-detainable, aside from offenses that are only detainable because of commitment to the Department of Corrections upon conviction, there are a number of other offenses that are listed as detainable offenses based on circumstance. And most of them deal with certain specific areas that the public is concerned about. One of those are domestic violence offenses. Domestic violence offenses, people can be detained. They can be detained if there are also orders of protection. Stalking cases, detention is allowable, even though they may be probationable. The same also for a number of gun offenses are also, although probationable, are mandatory, are possible detention offenses, as well as there's one other section I'm forgetting. Sex assault offenses. Even though some of those may be probationable, they are offenses that we can seek to detain. In each of those, we will have to file a petition alleging that it's an offense that qualifies for detention. And secondly, but most importantly, we have to prove by what's called clear and convincing evidence that the defendant is a danger to someone if they were to be released, or are suspected to be engaging in willful flight. And just showing that they previously failed to show up in court isn't sufficient. We have to actually show that they're planning on running away before we can detain them. There are some other sections at the law enforcement level that they can detain. If they're not satisfied, the person is telling them that they've got their right name. You have to be able to properly identify that individual. And also, if they have mental health issues, you may be able to detain them as well. But the big thing for my office, for when it comes to prosecution, is this idea of being able to prove by clear and convincing evidence, not by probable cause, which is the old standard for arrests, which is real low in terms of basis. We have to prove by clear and convincing not only that they are someone who is a danger to someone else and that they have a qualifying offense, but also that that individual, there's no other means that could be employed to keep them safely from engaging in other criminal activity. These are all things we have to show. And so that's going to ramp up our caseload in terms of the work volume considerably. So that's just a number of concerns and problems with the offenses and types of offenses.
Thank you. I appreciate that. Judge Adrian, he mentioned at the beginning of his comments there that about some judicial discretion. Under current law, judges do quite a bit of discretion on ruling on these cases based on individual circumstances. On January 1st, what changes when this law goes into effect in regards to judicial discretion on detainable offenses?
Well, you have very little discretion on detainable offenses. We used to have a lot of discretion as to the amount of bond, whether to set bond. Here, it's pretty clear that there are detainable offenses, and the state has to prove certain things to even detain a person for the most serious offenses. And that causes a problem. It causes several problems. Number one is just a bond hearing. What used to be a bond hearing now is a detention hearing. What evidence is acceptable in that? It used to be in bond hearings, you could take proffers from the state's attorney. You can have hearsay evidence, etc. Is all of that still admissible in this detention hearing? So you don't have any discretion, because you have to find by clear and convincing evidence, and you have to find that there's potential or there's harm to another person that's going to happen. So it takes all that discretion away from the judge in setting in whether or not to detain somebody. And certainly if it's not a detainable offense, then you can't detain them at all until they maybe commit another offense, where then the state could file a petition to detain them because they violated bond. But that's another step after you have to determine whether or not they're detained on the original offense.
Thank you, Judge. And just a quick follow-up on that. This new legislation outlines 7 specific detainable offenses. If someone is arrested and they're not under the enumerated detainable offenses, is there even an opportunity for a bail hearing in that instance?
No, there is not. You just simply can't detain them. And the problem the judges have is, of course, we're going to get the blame, because when somebody's arrested for, say, burglary, and you can't detain them on the first one, and they go out and they commit another burglary, or they go out and commit another offense, the public's going to look and say, well, who's the stupid judge who let him out in the first place? Well, we have no discretion on that. And so the judge who's going to be doing the detention hearings is the one that's going to, in the public's eye, get all the blame, because they're simply following the law, and the public doesn't understand the law, that you can't detain these people anymore.
Yeah, I think it's very, very important to point out that in section 110, 6.1, where it outlines the denial of pretrial release, the first part of that specifically says, upon verified petition by the state, the court shall hold a hearing and may deny, that's not a shall, they may deny a defendant pretrial release only if they come under those 7 categories. And those 7 categories do not, to my understanding, include that are going around on social media, like certain instances of second-degree murder, certain instances of kidnapping, and things of that nature. If they don't fall into those categories, then even having a bail hearing is seriously in question, and that's very, very irresponsible policy. But even if a situation where they get a hearing, it says very specifically in this that the only way that somebody can be detained is if they're a specific threat to a specific person. Is that your understanding, State's Attorney?
Yes, absolutely. That is one of the requirements, is that we prove that they are a specific threat to a specific person. In most of the sections, there is one section, and I think it was amended later on to include or community. I think that was an attempt to address the idea where someone has been murdered, so because the argument was being made, if somebody's dead because of someone's actions, then that person who killed them is no longer a threat to anyone because the person they attacked was dead.
Right.
That made no sense. I think they included the section about threat to an individual or community to address that, but again, it's very unclear.
It still has the specific language that it has to be a threat to a specific person. Sheriff Kuntz, would you like to jump in and like to hear your thoughts on these?
I do want to jump in because as I listen to this, I see this from a little different perspective. I know the state's attorney and the Honorable Judge Adrian, they talk about what happens when someone comes before them or they take someone to a bond hearing. But you know what really worries me is they may never get there because the police themselves cannot take someone in custody for a Class B, a Class C misdemeanor. And there are very specific things that have to happen for someone to be even taken into custody. And that's what concerns me. I believe in reform. I believe we should always work to be better, more transparent, but I don't see how that's going to make us any safer when we're so restricted on who that we can take into custody. And that was my point. I understand their points a little better now, but that really concerns me.
Sheriff, can I ask you a question? So as you read this act, if you have somebody that you would arrest, say, on a Class B or Class C misdemeanor, is it your opinion that you can't arrest them, you can't take them in for processing, you simply have to write them a ticket and let them go? Is that
absolutely
the way you read this?
That is the way I read it. If you have someone Class B misdemeanor and you can identify them, you believe they are who they say they are, they have identification. If they don't pose an obvious threat to a person or the community, or if they don't have an obvious medical or mental health problem, you don't have any choice. They're cited and released. You can't, in my opinion, and these are some of the questions that we still have, but in my opinion, I cannot take that person into jail for booking. He has to be cited and released because taking them to jail for booking would be in custody. Now, if I'm wrong, I hope we learn that before January 1st, but that's how I interpret it.
Yeah, Sheriff Kuntz, those are really good questions or really good comments. And, it leads to a lot of confusion on the part of law enforcement officers. All of a sudden, we're expecting law enforcement officers to make snap judgments on these legal matters and make snap judgments on, whether somebody in legal terms is a clear and convincing threat. Speak a little bit to the concerns of law enforcement officials being put in these positions. I mean, you guys are not attorneys. You don't parse every legal phrase. Talk about some of the complications that could come with that.
Well, probably what I know something my officers worry about is if you take someone into custody unlawfully, and then you're dealing with a Fourth Amendment violation, that's scary. That is not something we want to be involved in. And we'll be in federal court. And these decisions that we have to make, yes, we've got to make them on the spot and when it happens. The only thing, though, that I do want to get in, I want to say is I think what our saving grace, no matter what happens, is we have some excellent men and women that work in this community, that are police officers that have a vested interest in keeping their community safe. We've got some wonderful people at my department, and they will do the right thing. But I think we're putting them under a tremendous amount of stress and some more liability for trying to do their jobs.
Certainly putting them in a position where it's much harder to do their jobs and where they will be much more tentative in doing their jobs. Representative Miller.
Now, one of the questions that I have is it possible that this whole so-called Safety Act could be declared unconstitutional because of the threat to public safety that it imposes on the general public when you look at the real ramifications of what's going to happen if they implement this? Anybody?
Judge, you want to tackle that?
Can't answer that question. That would be an improper
Sure.
question for me to answer.
Understood. Understood.
I'll bravely take a chance. No guarantee that my opinion is correct, but my thought would be that if I used to teach criminal justice at a local university, so underlying the principles of why we pass laws in the legislature and constitutionality, the idea to impose restrictions on our community is to provide for public safety. That's why that's the reason we would make something a criminal law, is to provide for public safety, and you have to balance that against individual freedoms. And that's really the embodiment, in my view, of the Constitution, is that our Constitution is there to protect individual freedoms. I think it would be a difficult thing to argue on appeal that the act is unconstitutional because it is dangerous for people in the community. That's not typically a standard that's been used to challenge laws on a constitutional basis. So my general guess is that would probably not be a successful avenue of attack along those lines. It's certainly a very good argument about why we shouldn't have it, but legally, as far as a constitutional argument, I think it would be difficult.
Yeah, thank you. I appreciate that. I want to talk just a real little bit here about some of the things that the governor has said and has accused people of misinformation. The first one I mentioned briefly in my opening remarks when he was asked yesterday in a press conference whether or not they needed to make some changes to this law. He basically, but he said that. In his mind, this law was preventing situations like where a young single mother was caught shoplifting a box of diapers. That she spends 6 months in jail. Mr. State's Attorney, what's your response to that? Is that a realistic scenario or a realistic hypothetical? And do you think that the intent of this law and how it will actually play out is congruent with that?
Do I think it's congruent? Do I think that's why this law was passed? Absolutely not. Do I think it's a realistic scenario under any system of law? No, it's not. Yes, there are scenarios where somebody who commits a minor retail theft may spend time in pretrial detention. Usually, though, it's because that person has failed to appear in court several times and is not, fulfilled their obligation of showing up in court. That's what we want. That's what bail was primarily supposed to address, is making sure that people showed up in court. And when they didn't, we had the power to say, okay, you've screwed up again. You need to come to court. We're going to make sure you show up because we're going to hold you here. Right. Realistically, judges are not going to detain mothers in jail for shoplifting diapers. That's something that even prosecutors generally don't do unless they are a persistent shoplifter. If they keep doing it, I've had cases both as defense attorney and as prosecutor under the current bail reform, which was imposed about 5 or 6 years ago, which in my opinion does no service to the defendant themselves as well as the community. I've had cases that I can immediately think of in 2 instances where we had women who shoplift, get out because of the bail reduction that lets them out on the $30 a day reduction that currently exists. Shoplift again, do it again. One woman had 8 cases consecutively. Another woman had 6 cases consecutively. And I say that is no benefit to the defendant themselves, because under Illinois law, if you are out on bond, commit a new offense while on bond, then your sentence for the new offense is mandatorily consecutive. So instead of being, and in this case, the shoplifter had a history, so she was extended term eligible. So instead of being 1 to 6 for one offense, that if she'd been held in jail on and taken her medicine or been resolved in some way, now she's with 6 cases subject to 6 to 36 years. Now, admittedly, she's made her own decision to commit crimes again, but the system certainly hasn't helped her in any way.
Yeah, thank you. I appreciate that. I think it's fair to say that we probably ought to start making more decisions in Springfield based off of, data and real world practices instead of crazy hypotheticals like that. Under that bail reform law from 27, that person could be charged for that specific offense would be $100. So a lot of misinformation out there by the governor, a lot of pulling at emotional strings to try to deflect from what's actually going on. Another thing, and this I'll direct to the judge here. Another thing that the governor and some of the proponents are leaning back on this lately is they're saying that judges can detain anyone basically under any circumstances if they believe that they're a flight risk. Now this statute actually lines out in the enumerated in the 7 enumerated detainable offenses. Number 7 is this person could be detained if, and I quote, the person has a high likelihood of willful flight to avoid prosecution and is charged with, and then the list of felonies. I think that, just saying that they're a flight risk is doing it disservice because the statute specifically says willful flight, which is a totally different situation, Judge. Am I correct? What's the definition of willful flight? And furthermore, what's the bar to actually attain proof of that in the judicial system in order to detain somebody under this act?
Well, willful flight, there is no definition necessarily of willful flight. There's a definition of willful, and there's a definition of flight. And it used to be, if you didn't appear in court, then that was evidence of willful flight. Now you can't use that as evidence that a willful flighter, they're not going to show up in court. I don't know how you would prove willful flight at this point. Maybe if you, before you got arrested on an offense, you took off and went to another state, another country, and then got brought back, that may be willful flight. But other than that, the legislation itself makes it hard for even what used to be the obvious evidence of willful flight. We can't use that. So
yeah,
I don't know that I can answer that question.
Thank you. I appreciate that. State's Attorney, do you want to expand on willful different than just being a flight risk? And it is actually out legislation. It has to have, basically you have to have a specific intent to flee. You basically have to be saying that you're going to, or be in the airport with a ticket to somewhere. I mean, it's got to be clear and convincing evidence that you are a flight risk.
Yeah, and actually, and the judge is right, there's no definition currently of willful flight. The new statutes in section 110-1, section E, and that's what I was just looking up while the discussion was going on, defines willful flight for the purpose of the new, I refuse to call it Safety Act, the new Bail Reform Act, or Pretrial Detention Act. Willful flight means planning or attempting to intentionally evade prosecution by concealing oneself. And what the judge referred to in his comments is true also. Simple past non-appearance in court alone is not evidence of future intent to evade prosecution. So we can no longer go into the court and say, Judge, John Smith here has failed to appear in court 12 times before, so that's why we want him held in jail at a higher bond or held without bond under the new law, because that alone does not do it, even though it may be 27 times he's failed to appear in court. We have to prove by clear and convincing evidence that they have planned or attempted to intentionally evade prosecution by concealing themselves. And as you say, is that the instance where we catch them at the airport with a plane ticket to Kilimanjaro in their hand? That would possibly work. But again, as a defense attorney, there are many things I'd argue there as well. So yes, that is an issue that's going to come up in terms of the willful flight requirement. Realistically, as far as functionality, I don't see the willful flight reason for detaining someone being very effective under this law. I don't see it coming to play because you're not going to have that evidence to prove willful flight like the law requires. Most of the time, our argument is going to be one from a danger to a specific person or community.
Yeah, and thank you for that. I think that it's been pretty clearly established, and we've talked to state's attorneys all over the state, and thankfully a lot of them have chimed in on these concerns. There is real issues with being able to detain people that have committed these violent and egregious acts. Representative Halbrook, I think, has some questions. You're muted, Brad.
Sorry about that. Is that better?
Yep.
Yeah.
Excellent. So this may be a couple of things, points or questions for the sheriff. I'm just kind of curious, what about, is there any additional training requirements that's been mandated on our local law enforcement, both at the sheriff's department and local municipalities? What's that look like? What's that doing to your budgets as far as when it comes to mandated training, additional hours, things like that? If you want to speak to that, Sheriff.
There is a bunch of training that's now been mandated. Training from a police administrator's perspective is always a good thing, but it's also always expensive. I used to joke that I knew about what a day of mandated training cost. It was for the department, it was about $3,400 because that's what I do, work with the books. But the bad thing about this is all this extra training comes without funding. And that's a problem for our governing body, for our agency. Again, training is always good, but we've got to pay for that. Today, I spent time in our mobile training board of directors meeting, and we are going to have to raise the rates for our participating agencies. That's what the discussion was all about, because there is so much mandated training that has to be provided. It's got to be paid for. So even though I think training's a great thing, it's another unfunded mandate for my department and several other departments also.
Excellent. One other question, and then I think I'm going to kick it back over to Adam. I think he's back on with a better connection. But my question is, what's the status of body cams? Is there an enactment date for that? How are you guys handling that?
For a department our size, I believe it's in 2025, we have to have body cams in place. That's another issue that's very expensive. We are not in body cams yet. The reason for that is, I hope there will be more funding available and body cams continuously improve. But my biggest concern right now is figuring out how to store that information. And there's still a lot of questions about when cameras can be turned on, when they cannot be turned off. And I think a lot of that's not really been settled. I'm sort of waiting for the dust to settle yet. I mean, we welcome cameras to the fact that just like our in-car video cameras, they prove that we did the right thing. So we have nothing against cameras, but they are expensive, and I've got the issue of where to store all that information and video, and also with freedom of information, how to be able to redact portions of that video that can't be released. So there's still a lot to figure out there. There's still a lot of questions. I don't believe the dust has settled on that.
Yeah, thank you for those answers, Sheriff. And I think that's true. I think just mandating or saying, hey, body cams, and I think there's probably some good things to have those, but that's just kind of, to me, it seems like the tip of the iceberg. And a lot of times we don't think about FOIA, and you mentioned that there in your closing remark, is if you've taken video and there's a crowd of people, how do you redact all of those people out of there except the necessary ones that need to be? And then you have that, again, that issue of storage of all that data, the video. These are just very complicated things that the cameras are probably the easy part of it.
Well,
Go ahead.
I am going to welcome cameras. I think when we get them, and I would go as far as I would like to have all my jail staff with cameras, because, like I mentioned, we've got good people there. You know, we always work to do the right thing, and I think cameras will prove if there's a question that we did the right thing. But still, there are a lot of questions when they can be used, when they can't be used, when they can't be turned off in the storage, and yeah. Like I said, there's still a lot of things that need to be settled with them.
Excellent, Sheriff. Thank you. I think if we've got Adam Niemerg, we're going to try to bring him on and see make sure he's got a good connection. Adam, you're back.
Can you hear me okay?
We'll give it a try.
Uh-oh.
Uh-oh.
You're not back.
All right. Well, while he's working on a better connection, this maybe just kind of open it up to anybody there of our experts or what others have seen in their respective representative districts. What have you guys seen as far as retirements, early retirements of those in law enforcement, and kind of a compound question? What's this doing for recruiting of law enforcement officers? What have you seen over the last 12 to 16 months, and what's the crystal ball look like for the future when it comes to recruiting? And I'll just open that up to anybody that wants to jump in there with that.
I would like to jump in on that because I have some firsthand experience. We tested about 2 weeks ago, and in 1984, when I took the test for our agency, there were probably 60 or 70 people there testing. When we tested a little less than 2 weeks ago, we had 9 people sign up and 5 people showed up. So I think that gives you an idea about, how hard it is to find good candidates now. People, I don't think as a whole, they want to be the police like they were at one time. And that's what's really sad about that is we need the brightest and the best people. Those are the people you want in these positions. People that are going to do the right thing at 3 a.m. when no one else is watching, and smart people. So that's very disheartening. And we've had roundtable discussions. How do we correct this? How do we fix this? And I don't have an answer for that. I think this may be a little off topic, but one thing a police officer has is his love for his community and his desire to serve. And I think once you maybe demonize them to a certain extent, or take that away from them, it's much harder to get people to serve. So, and that may be a little emotional. Of course, I see it differently, because I live it. I love the people at my department. I love my department. They're, hardworking, dedicated, courageous young people. But that is a problem. And if someone here has an answer, I would love to hear it.
Thank you for that, Sheriff. I don't know, State's Attorney Reeder, any thoughts how recruiting or early retirements in these law enforcement departments have affected how you do your job? Have you seen anything? Has that been impactful at all or not?
It does. It impacts our profession in a number of ways. Yes, we are seeing a number of officers who are taking retirement early. We're seeing departments that aren't able to recruit the numbers that they were able to recruit before. That affects the safety of the community from the sense of there are times when we need a number of officers in court for trials or for something called preliminary hearings. That takes officers off the street when they should be protecting the community. Oftentimes, officers, upon retiring, will move away. That increase costs and difficulty of getting them back as witnesses for cases that they may have been the officer that worked the case, but now they're retired. Now we have to go. We've got one fellow in Texas we have to get back, one other in Florida for trials. That increases the cost to the community. So there's you're going to have a certain amount of that, but we have more of it because officers are retiring early. So that does affect it. And I will say that getting officers, that's clearly a problem. And as we all know, because of current economic conditions, any recruitment for jobs is difficult these days. I myself, whining on my own behalf, I have a shortage of attorneys on staff that I haven't been able to fill simply because we don't have qualified applicants applying. And I've heard that from a number of my colleagues as well.
Thank you for that. I think Representative Miller, did you have a couple of thoughts or questions you wanted to bring back into this conversation?
Yeah, I did have a couple of questions. There's all kinds of horror stories about what happens on January 1st. As far, some of the things we've heard is they're going to empty the jails. And I know that it's either Will or Lake County has 640 prisoners being released. Is that true, or is that just fear mongering, or what's happening in reality?
Chris,
can I speak to?
Yeah, go ahead.
Can I speak to that? Because there are only certain offenses that can be detained. We have discussed at our judges meeting what we do with the people who are incarcerated come January 1st. We have decided to meet with the state's attorney and the sheriff, who of course is in charge of the jail, to determine on January 1st who gets released, who doesn't get released, who can be detained. And then the next issue is even the people who are detained under the law that takes effect January the 1st, they can only be detained for 90 days before they go to trial. If they're not taken to trial within 90 days, they get released. So it's a huge problem. And, I'd like to ask State's Attorney Reeder what that's going to do to his office when anybody who's detained has to go to trial within 9 days. How much of a problem is that, especially when the state crime lab has promised to get your DNA evidence back within 6 months?
Well, there's a number of problems there. First of all, the practicality of the 90-day rule. As the judge, I'm sure, knows, many times it's a speedy trial issue is what that is. Right now, speedy trial is 120 days, and we rarely violate speedy trial. We're always aware of it, something to look at. But realistically, most of those continuances come from the defense. So it doesn't really impact us. Now, sure, there can be defendants who are going to demand their speedy trial. But I realistically don't see the defense bar changing their pattern very much. I think they will still continue to continue matters so that the 90-day issue won't, in my estimation, be that big a deal. That is a problem. It is something we need to keep an eye on. But I think like speedy trial now, defense can request continuance and it'll toll that period. At least I hope that's the way the law will work. That's the way speedy trial has traditionally worked. If not, then we've got a real problem. Now, as far as some of the other issues, though, with respect to that, and again, the same with the labs returning evidence, there are currently under speedy trial some abilities on the part of the state to be able to continue a trial based on lab and go beyond the speedy trial date. That's a real question about whether or not that applies anymore. That this law may eviscerate that aspect of it. and we may have some issues there. That's certainly a possibility, but that's something that hasn't been addressed. That's something that's not talked about. That's another place where this statute falls down because of its silence on important issues. With respect to actual impact on the office, as the judge, I'm sure, is aware, and we know, is that these are all going to require more time to prepare for these detention hearings. Realistically, for a county my size, we probably should have somebody that's their entire job as an assistant state's attorney. And as I mentioned a little bit earlier, I'm down staff anyway, so that's going to be a big drain. The other problem here, too, with respect to all of that, is that if people that are currently in jail, and as take my county, for example. Now, we don't know exactly what the numbers of people will look like come January 1st. There'll be some turnover in the jail population. But right now, our jail has about 360 people in it. About 40 of those are federal prisoners through the feds pay us to keep them, and that's a program that brings money in for the county. So 320. Of that 320, not really sure the exact number because it will change, but as far as a guess, maybe about 100 of those people are people that are detained because they previously failed to appear in court on cases where they cannot be detained any longer. And as of January 1st, bail bond system all gone. No such thing as bail. So those 100 people that are being held because they previously failed to appear, they're going to be held on non-detainable offenses, so they're going to get out, in our opinion. That leaves maybe 160 in Macon County that can be detained because of the nature of the offense. Well, again, they're only being detained because bond has been set and they haven't been able to post. They haven't had a hearing under the new act as to whether or not they should be detained. So what we envision, I've been meeting with our judge that will be doing that, the chief public defender, and also probation to talk about this issue. We think that as of January 1st, we're going to have 160 people that we're going to have to pretty quickly have hearings on to see if they can continue to be detained. We're developing a plan to try and do that the last couple of weeks in December before January 1st, and saying that at the end of the hearing that, the imposition of the result of the hearing will take effect January 1st. But that's absolutely true. If we don't prove as of January 1st that they are someone who needs to be detained, they would get out.
Scott, I didn't think of that. Do you think that on January 1st, you have 48 hours to get all these people through a detention hearing?
Absolutely. I think, well, and the 48 hours, that's something that's not for everyone either. There's some variation there. One of them is 24 hours. But yes, we certainly we are going to be limited by the statutory authority, whatever it correctly is.
We in our circuit are talking about having those detention hearings before January the 1st. And that's what we're meeting about right now, is determine who needs the detention hearing and trying to set those up prior to January the 1st. So we are not caught on January the 2nd with 100 detention hearings that we have to do.
Thank you, gentlemen. And I guess that's the question. We see some comments here too, and I'm going to try to kick this back over to Adam in just a moment. But so we can literally see people meeting on January 1st. That's a Sunday. I mean, usually folks take a long holiday week there with Christmas and New Year's, and now you got New Year's Eve is going to be the Saturday, and it looks like New Year's Day is Sunday. I think this is going to be kind of problematic. Any closing thoughts real quick from anyone, and then we'll kick it back over to Adam on that thought.
If we can
Adam,
you guys hear me?
Yep, go ahead.
Holy cow, you can hear me. This is amazing. I'm everybody for that issue on the mic there. But perhaps this question can be to the attorney or the judge. Now we've had a conversation about non-detention as it relates to a clear danger to that. You've had conversation about having January 1st immediately in the offices. What degree do you feel that you would have to detain that individual, and what do you think the state of you to have that detained? That once that's done, what are your concerns if you of them actually being able to saying that's not enough information?
Well, if you're talking, and I'm sorry, Adam, you're still breaking up a little bit, so it's a little hard to follow. In terms of if you're talking about the evidence that a judge would find sufficient to make a decision to detain someone, is that what you're addressing there?
Yes. Can you hear me okay now? Is that
Yeah, there we go.
okay?
Yeah, you know, the current, you know, in the law, there's a number of what are called burdens of proof. Not in the courtroom, but at the arrest stage, officers must have an articulable suspicion to do any kind of initial action. And then beyond that articulable suspicion, there's probable cause, and that's usually to make an arrest, or in the court system, that's at a preliminary hearing when someone's charged with a felony. Court has to find that there's basically a rational reason why this person was arrested for this specific crime. Then, in civil lawsuits, you have to prove a case by a preponderance of the evidence. The court does not like to define that in terms of percentage, but the way it's been expressed is that the scales of justice ever so slightly balance in favor of one side or the other is a preponderance of the evidence. All right. So I will jump out of a limb on and say 50.00001% is preponderance of the evidence, just for example. And it depends on the circumstance and the trier of facts decision. Then in a number of hearings, there's a burden of proof level called clear and convincing evidence. And that's what we typically need to, say, commit someone to a mental health facility because they're a danger to themselves or to others. In involuntary commitment proceedings, that's the burden of proof is clear and convincing. And then, of course, you have the highest burden of proof, which is the standard in criminal cases in a jury trial or a bench trial, and that's proof beyond a reasonable doubt. And a jury determines what is the reasonable doubt and whether that burden's been met or not. So now, instead of probable cause, which is what we have just at a preliminary hearing to show that someone committed an offense, which we still have preliminary hearings, and we still don't know how those incorporate into this when we're proving that they need to be detained by clear and convincing evidence, but still have to have a preliminary hearing. That's a whole nother can of worms. Now we have to basically prove them that the likelihood that they have committed an offense, and the evidence is great, by clear and convincing evidence is the second highest standard under the law. Jokingly, I've been saying basically we have to prove them guilty before we prove them guilty to detain them. But that's what it comes down to.
Do you think that that with the new law, through the preponderance of evidence and the degrees that you will have to go through to detain that particular, some states' attorneys might decide to release the arsonists, the burglars, because they're worried about the state or somebody coming down and saying you did not unnecessarily, and it violates this particular law?
Whether or not there'll be sanctions against the state's attorney's office for trying, I mean, ultimately, because if we're doing this hearing, if it's a contested hearing, I can't imagine that there'll be many defendants who will agree to be detained. So they'll all be contested hearings. But contested hearing, oh, by the way, that's another thing under the statute. Decision to detain or not detain can be appealed by either the state or the defendant under this law. So the defendant, if he gets detained, can institute an appeal, where normally appeals aren't until the final decision by the court. Does that delay the proceedings if there's an appeal that's requested? That's another issue that hasn't been answered. And if it's by what happens traditionally, if a defendant appeals, that delays the proceedings, which means they're just sitting in jail if they've been detained and they're not getting what they should have gotten. So realistically, is that going to be the effect? Probably not. But that's something we don't know. It's not answered in this law, like many things. So the issue of whether to detain or not to detain with respect to the appeal issue is going to be another problem that's entered in here as well.
Okay, and this question will up kind of on detaining individuals. Sheriff Coons, there's been a lot about criminal trespass or just trespass in general. If a person is property and you call the police on that individual, that the law enforcement issuing a citation, and unless there is a clear threat, homeowner, you're not allowed to detain that subject. Is that, how are you interpreting that? Are you getting to see that going forward?
We talked about, that's been a hot topic of discussion, within the department. I think we are going to have to see some clarification on that from legislators. I mean, I'm not sure, but I do know this. If someone is on my front porch and refuses to leave, even after directed by law enforcement, to me, I would take that as a threatening situation. And I think he would have to be detained, but that's not, completely decided yet. I know we've got men and women out there that are going to do the right thing, that would never leave someone hanging like that. But I think we're going to need some clarification on that. If anybody else has, a better answer than that, I'd sure like to hear it, because that worries us.
Judge, maybe you could elaborate on that particular issue.
Well, that's really outside my purview as to what the sheriff's department or what police should do as far as taking into custody. I really can't comment on that. That's not in my area expertise.
Okay. Yeah, it sounds to me, and correct me if I'm wrong, maybe State's Attorney Reeder or even Sheriff, like it's very open to interpretation, and it could be interpreted in different parts. Individual could be on somebody's property and a citation is issued, and whether it be officers are worried about interpretation of the law or they're worried about actual liability against the department, may not be detained from a person's property. Is that a stretch, or is that something that?
Yeah.
Well, go ahead, Sheriff.
Go ahead, Scott.
No, please. You're better suited, I think.
Well, I didn't catch all of that, Adam, but I think if that could be interpreted by law enforcement, if someone is on that property and they've been asked to leave or they've been ordered to leave by law enforcement, that's a lawful order, or it was. And I would think that the homeowner or whoever was on would feel threatened over that. So I would imagine we would, but still, we're concerned about liability. You're never concerned about liability to the point that you don't do the right thing. But yeah, liability is a question about whether that person, what the law says, whether they can be detained or taken into custody. But again, we are not going to leave somebody, at the mercy of an aggressor or someone that's, going to commit a crime. We're not going to do that.
Absolutely. Thank you very much. My connection is still are we still having issues with my connection? Everybody hear me okay?
Yes, sir, we are. We're still having issues.
Wonderful. Oh, we're still right. I guess if maybe kick it back to Blaine for a second if I'm having issues here.
Yeah, thanks, Adam. On the trespassing thing, obviously that is something that has gotten a lot of attention, and my understanding is hypothetically somebody could be on your property, not in your house, but on your property. Let's say they set up a tent on your property. They weren't threatening anybody or doing anything else. They were just basically hanging out there doing their thing. My understanding of the legislation is the police officers, all they could do is cite them. They could not forcibly remove them without the clear evidence that these people specific threat. So it is definitely a problem. And Sheriff Koontz, you hit it right on the head. You know, when you said that there needs to be a lot more clarity to this, there certainly does. This is another instance where we're putting law enforcement people behind the eight ball because we're lacking clarity on what we're doing in the legislature here. So I appreciate that stuff. State's Attorney Reeder, there is, you know, if we eliminate all cash bail, which is what we're doing in January, what's the financial impact of that on our counties?
That's you know, you get into kind of a bit of trouble talking about that, in the sense that you don't want to be seen as raising money off of folks that are in unfortunate circumstances. But the truth is, there's going to be a huge financial impact, I believe. And again, I could be wrong, but I think there will be. The issue is that people who are in jail really want to get out, and they will then file their bond to get out of jail. Ultimately, a large number of those people get convicted, plead guilty to something, and as a result, they will have court costs. When they posted bail money, the money gets taken to be used for court costs. And a substantial amount of the money that the criminal justice system raises now comes from the payment of bail. And so that money is no longer going to be there. Then what we have to rely on is the ability to collect money after conviction from people who are convicted of crimes. I think we can all imagine realistically how that's going to go. We do have debt. We are allowed to use debt collection entities these days, and many counties do. We do in Macon County, and they bring in a fair amount, but it's not going to be anywhere near what is recovered through the bail and apply to cost system that there is now. I do want to say one thing. I don't think the judge can say, and in his defense, there are a number of these topics we've talked about tonight that he can't address because of his position as a judge. Judge is required to maintain neutrality in all things, and so some of the questions we put to him, it looks like maybe he's evading an answer, and he is, because he can't answer under his ethics conduct as a judge. I want to give him that little shout out for him.
I appreciate that we still have ethical behavior here in the state of Illinois.
Thank you. Can I explain something else about the bond situation? Because most people don't understand, when a defendant posts a bond with the circuit clerk keeps 10% of that bond. Regardless of what happens, the circuit clerk keeps 10% of that bond. That goes into a fund to fund the court system. And so when you remove cash bail, if you think about it, all the thousands and thousands of people who have posted a cash bond, 10% of that used to be used to fund the court system. Now you don't have cash bond. There is no money there. It's going to be a huge problem. We've looked at that in our county as to how do we make up that shortfall. And that's the way it's been for a number of years. And unfortunately, or maybe appropriately, I don't know, depending on how you want to look at it, that's the way a lot of the court system was funded, with that 10% from the cash bond that was posted. And you're not going to have that. And so it's not only a problem for the court people, it's a problem for the county boards, because now the county boards are going to have to make up that funding from somewhere.
Yeah, that's a great point, Judge. The funding is going to have to come from somewhere, and when these sources are eliminated in the state of Illinois, we know what happens when there's supposed funding shortfalls. But there's a lot of things that we could cover with this topic. This is over a 700-page bill, very, very complicated. There's we've covered the bail stuff tonight. We've covered some of the trespassing stuff. There's still a lot of things out there on, electronic monitoring precedents in other states, and a multitude of things that we could cover. But unfortunately, we would need all night and all day tomorrow to do that. So we want to get this thing out of here by 7:30. So I would like to give each of our guests the opportunity to kind of give some closing comments and hit on some things that you think that are important, and most importantly, what can people do? What should the legislature be doing? What's the path forward to correcting this thing? Sheriff Koontz, if you don't mind, we'll kick it off with you.
Well, we are fortunate in Effingham County. Our population, our citizens, support the police by and far for the most part. And so as an example, though, of something, I was on a town hall meeting as a guest, watching a town hall meeting put on about the new no cash bail. And there were several people speaking. It was very informative, but the comments coming from on the side, people could put comments in. I was surprised at some of them. They'd say, well, how are we going to keep the cops from detaining someone without just cause? Now, and I couldn't tell who some of these people were because I only had the names, but I suspect some of them were, educators and people involved in the system. And that really shocked me, that the police seem to be, the whole problem in this. And that's why I think, it's hard to get people everywhere, but that's why it's hard to get good people in law enforcement right now. Thank goodness, where I'm from, we have good community support, and we work hard to keep that because you cannot have effective policing without community support. So I don't have that answer, but thank goodness I'm from where I am, and that's what I could say, to make sure you support your police. You have to hold them accountable, of course, but we have to have that public support. And I appreciate
thank you.
the opportunity to say that.
Yeah, and we definitely appreciate you, Sheriff Koontz, and we are certainly blessed with great law enforcement officials all across the state. I'm a little partial to right here, so thank you for being here tonight. Judge, any final thoughts from you, and maybe some recommendations moving forward?
I don't know that I can make recommendations that I'm supposed to do that. I would just tell you that the judges are taking this seriously. It's a huge change in the criminal justice system, and we are doing our best to try and make this work the best we can. It's very vague in certain places. There are no definite answers to anything because, of course, it's never been through the appeal system. And so you can be assured that the judges are trying to make this law work as best as we can.
Thank you, and I appreciate that, and I appreciate you taking the time to be here. Your expertise and knowledge is very, very much appreciated. State's Attorney Reeder, to you the same stuff moving forward, and just kind of wrap up on
thanks.
things that you think are important.
Thanks again to all the legislators of the Freedom Caucus that allowed us to come on and share this information with the public. Dan and I, Dan Calkins represents part of the same district that I'm in Macon County, and we see each other quite a bit. We were talking the other night about what we think will happen. Obviously, the real solution here is for something to be done legislatively. Ideally, that would be a change in the representatives in the House of Representatives in Illinois and the Senate. That may be difficult in some locations, but the public making their feelings known to the legislators that are there. As Dan was saying, I was asking him do we see anything happening before January 1st to correct the problems in this bill, especially the great problems, I think, that exist with guidance in terms of how this is all supposed to work in implementation. And his response was and I hope I'm not telling stories out of school, Dan, but his response was he didn't think anything would change before the election. Hopefully, though, after that and the veto session between early November and January 1st, hopefully we will see some legislative action to redress some of these issues in the bill, that the problems that we see in it and in implementation, and some of the inequities that exist as a result of it. I hope that's the case. I would encourage the citizens of the state to contact your legislators to start putting on the pressure to bring about appropriate change to this debacle that was passed late one night in a prior veto session.
Yeah, thank you. Thank you, State's Attorney Reeder. And yeah, it is abundantly clear that we are going to need legislative remedies in order to get past this. Representative Calkins, we're going to give you one more shot here. If you don't mind, if you could touch on that, and since you've been uncharacteristically quiet here, we'll give you some time to know your thoughts.
Well, I hope the volume okay, Blaine.
Well, you haven't talked enough yet, Dan.
I was breaking up before the issue. We put pressure on members of the General Assembly. The Democrats have got to feel forward. Start talking to the talk to them. We have the veto session 6 to, at the very least, of parts of this bill. Mike agreed to do that with his political, and it's terrible that holding this state hostage because of his ambition. But we'll try. The pressure in this is going to be huge. Public safety. We'll continue to work and fight for the people in this state. That the Democrats slap together and throw it out on the table, poorly thought out as yes. This bill is full of these and ambiguities and way to run a state. Blaine, and thank you so much. A very, very productive evening. Thanks to all of our.
Yeah, thanks, Dan. I appreciate that. You're in and out a little bit there, but Representative Niemerg, we'll see if we can give you a shot here. What kind of actions do you think that we need to see from the legislature to remedy this? What's the steps there, and some closing thoughts from you?
Well, first off, Blaine stepping up to moderate tonight with my for assisting in that capacity. We need to talk about repealing the Safety Act. There's been ran that really don't do up the implementation of the Safety Act. Here with us, this thing will have to be deep. So we need to be looking at a total repeal when it's pushed through at 4 or 5 in the morning, given 45 minutes to review. That there's going to be some major issues. I think all the as well as my colleagues, and going to happen in veto session, and we'll get through.
Yeah, thanks, Adam. I appreciate that, Chris. Same to you. Thoughts, closing thoughts, and what should citizens be doing to make sure that their voices are heard on this?
Well, thanks, Blaine, and thank to all of you guys that jumped on here tonight to help us have a moment of discovery for the citizens out there. I think that one of the things that needs to happen is that is that this piece of legislation needs to be wadded up and thrown in the garbage because it's a garbage piece of legislation. It doesn't. It's like everything else in Springfield. We deal with symptoms and don't ever get to the root cause. But the root cause of what we see going on in our state is fatherlessness and a lack of a masculine Christian role model in the homes. And there's no one to say no. There's no discipline. And eventually, a young man particularly will keep pressing the boundaries until somebody tells them no. And unfortunately, that's they end up in with the police and end up in the courts. And I know that when I was growing up, there was a slogan that you saw on TV all the time. It was, if you do the crime, you do the time. And some of you guys that are a little bit older, like I am, probably remember that campaign. But I know when I heard that as a young man, I thought, I want to behave myself because I don't want to do the time. And we have plenty of laws on the book. We just need to give our men in blue the ability to enforce the law. And J.B. Pritzker, Lori Lightfoot, and Kim Foxx are more like the Three Stooges rather than leaders of the state of Illinois. And they brought chaos and tragedy to the city as a result of their lack of ability to govern it properly. And so we need to continue to go, and we need to call our people. We need to hold our elected officials accountable. And then November the 8th, possibly we need to change some people out. So that's my thoughts.
Amen, Chris. Thank you very much. Representative Halbrook.
Thank you, Blaine. And I'd like to say thanks to our special guest this evening that's been with us, Sheriff Coons and State's Attorney Reeder and Judge Adrian. Appreciate you guys' insight from your respective points of view, your professional positions. There's a lot to sort out here, but I just want to encourage everyone that's been on this call. I know we've had almost an hour and a half and had a few technical difficulties, but hopefully the information's been good. And hopefully you've been able to get something from it. You'll be able to go back and replay and listen to it again. But, I think the only real answer here, we're going to hear about trailer bills and minor fixes and tweaks here and there. But I think the only real answer is this just going to have to be repealed. I don't know that we know the ramifications of how far and wide and how damaging long term this is really going to be to our communities, both from a public safety aspect, from a budgetary aspect. We're just really not sure how this is all going to shake out. When you try to pass these 700-800 page bills in the wee hours of the morning, when nobody's paying attention, it's just going to be very difficult. So with that, Blaine and others, thank you all for being on tonight. And thanks to our viewers that have taken some time out of their evening to be with us. And hopefully we look forward to everybody being with us in Arthur next Tuesday evening for our educational and Amendment 1 town hall. Blaine, back to you.
Yep. No, great stuff, Brad. Really. I think it's important to point out that I don't think that anybody on this panel here is opposed to certain reforms. But, oftentimes or almost all the time in Springfield right now with the imbalance in power, it's all or nothing. This policy, it's clearly prioritizing criminals over victims, and that's not what we need. We can set some appropriate boundaries here, do some things like some other states like New Jersey have done, and give real judicial discretion. But at the end of the day, J.B. Pritzker and the Illinois legislature, ran by supermajority Democrats, they ignored all of the best practices. They ignored all of the data on this. They ignored the Illinois Supreme Court Commission that clearly stated that if you do this without putting these specific parameters into place, it's going to be a mistake. They rammed it through because that's what they care about at the end of the day. They care about putting out their press releases and being the most progressive progressive people in the country. And this stuff didn't happen by accident. These legislators, we didn't know everything that was in the bill, but we knew enough we knew it wasn't going to be a bad idea. It was going to be a bad idea. We knew it was going to be a bad idea because they've done this. They've tried this across the country. And this stuff was talked about. They did this in New York probably 2 years before we even broached this in Illinois, and it was a complete disaster there. And they ignored that. Even Bill de Blasio, who is a noted socialist, mayor of New York City, stated that this cashless bill was a disaster. It was unworkable, and the legislature has to go back and do something about it. We had the facts. We knew that when they did this in New York, that robberies went up 33%, assaults went up 10%, burglaries went up 20%, grand larceny went up 24%, grand larceny auto went up 62%. They knew that, all that. They did it anyway. It's irresponsible. There needs to be political consequences for this. And moving forward, we need to not only repeal the Safety Act, but we need to put policies in place that protect citizens from these dangerous type policies. If you put a policy like this on the ballot, there is no way in Illinois voters would vote to approve these draconian policies. The state of California instituted their cashless bill through the legislature. They have a referendum process in California that they actually, the citizens of California petitioned to put this on the ballot, and the citizens overturned this legislation in California. That's the kind of things that we need to be working on in the state of Illinois, and that's the kind of things that the Illinois State Freedom Caucus is going to be working on in the future here. So we appreciate you guys. We appreciate your support. And we appreciate all of our guests being here this evening. And this is something that this group is going to continue to do. We're going to continue to push the issues that are important. We said when we got into this thing that we may not be able to affect policy overnight, but we're going to make sure that everybody in our districts and everybody that will listen to us knows what's going on in Springfield.
Yep.
Because when people know what's going on in Springfield, step to changing things for the better in Springfield. So like Brad said, join us in Arthur this Tuesday, starting at 6 p.m. at Yoder's Kitchen. It's got great pie, great coffee, and we're going to talk about really important issues that haven't been covered nearly enough. The so-called Workers' Rights Amendment that's going to a constitutional amendment that is going to be on the ballot. Extremely, extremely important, extremely impactful stuff. And we're going to be talking about some of the stuff that's happening in the education sector. We've got the foremost expert in the state of Illinois on some of these issues, Ted Dabrowski, coming down to talk. So join us there at 6 p.m. And until then, we appreciate everybody, and we'll see you on Tuesday.
Night, everyone.
Yep. Thank you.